A commercial fishing company could potentially have a significant impact on things like social services, the IRS, the FDA, the CDC, the Federal Trade Commission. I could go on and on. It sounds crazy, but it's true. Now, I didn't pay attention to this at first because, it's commercial fishing. It's not something I really have anything to do with. Here's what I know and why I'm paying attention. This fishing company is suing the National Marine Fisheries Services. It's their governing federal agency. Even though they've lost twice in lower federal courts, the Supreme Court has agreed to hear their case. In 1976, the federal government set limits on how much fishing companies could catch to prevent overfishing in something called the Magnuson-Stevens Act. To ensure compliance, a government-appointed inspector is required to ride along on every fishing trip. The cost of this inspector is about $700 a day. However, the MSA does not define who is responsible for this cost. The NMFS, so the federal agency, has interpreted, and that's the most important word, interpreted, their law to say that it's the fishing company's responsibility to bear this cost. The fishing company obviously disagrees and wants a federal ruling. However, they can't get one because of something called the Chevron deference. In 1984, the Chevron deference was basically Congress saying there are areas of our government and our country that need a lot of oversight, but we as the government and our judicial system just can't manage it. Instead, here's an agency that's going to manage all that. There you go, problem solved. To ensure the success of the agencies they were creating, Congress gave them, not the federal court, they gave the federal agencies the ability to interpret and define anything within their own laws that is vague or unclear, and empowered them to use their interpretation in their enforcement efforts. This is how the NMFS was allowed to interpret the law. The fishing company wants the federal government or federal courts to define these vague areas because, let's be honest, is an agency really going to make an interpretation or define something in a way that harms them? Probably not. The initial goal of the Chevron deference was to prevent the lower federal courts from being bogged down by all of these cases and to prevent lower courts from basically making policy for federal agencies. Talk about everything grinding to a halt while everyone fights over the definitions of basic words. Here's a great example. Recently, I've been dealing with Medicare, and a huge issue has been how Medicare has decided to interpret and define the word credible when it comes to prescription insurance in order to enforce a variable fine on individuals every month for the rest of their life. Now, credible isn't a word that typically has a lot of definitions or interpretations, but this federal agency has been empowered to create their own definition, create their own interpretation, and use it to enforce additional fees, restrictions, and fines. And we have no recourse, no one to go to get a different definition. Now, the Supreme Court has to decide who gets to make interpretations for things that are vague. Is it going to be the federal government and courts, or is it going to be the federal agencies that they have created? This could have major implications everywhere. I just shared a Medicare example, but think about the agencies we depend on. The FDA could change their regulations like they did in the early 80s with the HIV medication scandals. They could start pulling medicines off the shelves or halting medical research. The Federal Trade Commission could interpret their laws to restrict stock market activity or cease gains on various actions. What about social services? This is a doozy. Their interpretations can affect the definition of disability, abuse, neglect. They could change benefit eligibility, change qualification requirements, even change when and how children are to be removed from the home. There is not a time or an instance in history that I can think of when one group's power has been validated or enforced, especially by the courts, that all the others have not taken notice and used that as an opportunity to flex their own power. So you can imagine what the potential outcome of this case could mean. I am not a lawyer. I am not a doctor. I do not work for social services. I am someone who's living with chronic illness, and I see what happens when I go to the doctor or I go to the emergency room. I know what it's like to go up against some of these agencies. It is hell. What makes it even harder is that they have the ability to change the interpretation and definitions of their laws before I can even make it to the bottom of their most recent form. Well, it may be starting with commercial fishermen and a $700 inspector fee. I'm a little scared because that's not all we're talking about. We're also talking about decisions and interpretations that can change lives forever. That's a